morning. Welcome to the Supreme Court of the United Kingdom. Today we are hearing an appeal in the matter of Harcus Sinclair LLP and Your Lawyers Limited. The appeal concerns a non-compete clause contained in an agreement between two firms of solicitors. The issues include whether the clause was an unlawful restraint of trade, whether it might be enforceable as a solicitor's undertaking. The appeal will be heard over 2 days, today and tomorrow. I'm Lord Lloyd Jones, and I'm sitting today with Lord Briggs.
Good morning.
Lady Arden.
Good morning.
Lord Hamblin.
Good morning.
And Lord Burrows.
Good morning.
The appellant, Your Lawyers Limited, is represented by Richard Coleman, Queen's Counsel, and Philip Alquist. Respondent, Harcus Sinclair LLP, is represented by Jonathan Crowe, Queen's Counsel, Jaudat Khurshid, Queen's Counsel, and Josephine Higgs. Mr. Coleman.
May it please the court. There are 6 issues. The first 4 concerns the court's inherent jurisdiction over solicitors as officers of the court and the interaction of that jurisdiction with the restraint of trade doctrine. That jurisdiction has not been considered at the highest level since Myers and Allman was decided in 1940. The first of the agreed issues, which you have at pages 67 to 69 of the electronic bundle, is the respondent's issue. Was the second respondent, Mr. Parker, acting in his capacity as a solicitor when he gave the undertaking on behalf of the first respondent, Harcus Sinclair LLP? We say that there is no basis for interfering with the judge's finding that Mr. Parker was acting in his capacity as a solicitor. Your lawyers, the appellant, gave Mr. Parker the privilege and confidential information against his undertaking, so Mr. Parker could provide legal advice. Issues 2 and 3 raise important questions about the enforcement of solicitors' undertakings under the inherent jurisdiction. In Kleinwort Benson and Lincoln City Council, Lord Gough said this: "The common law is a living system of law, reacting to new events and new ideas, and so capable of providing the citizens of this country with a system of practical justice relevant to the times in which they live." Lord Wilson cited that dictum in his judgment in Peninsula Securities, see page 1563 of the bundle. The new situation in the present case is the application of the supervisory jurisdiction to a body corporate through which a solicitor practices under the modern regulatory framework, and on behalf of which a solicitor has given an undertaking, we say, in his capacity as a solicitor. It is for the courts to determine the scope of their inherent jurisdiction, subject to the sovereignty of Parliament. The supervisory jurisdiction over solicitors is concerned with professional conduct, not with legal rights and liabilities. It is the appellant's case that a court of professional conduct should not recognise any distinction between Harcus Sinclair and Mr. Parker in relation to the undertaking. If the decisions of the courts below are correct, then the court's power to enforce undertakings under the inherent jurisdiction has been seriously undermined. The courts below held that they were bound by the decision of the Court of Appeal in Asabayev and Michael Wilson and Partners Limited, which is at page 1295 of the bundle. They held that they were bound to hold that they had no inherent jurisdiction to make an order against Harcus Sinclair to enforce the undertaking. The reason is said to be that Harcus Sinclair is not an officer of the court. I submit that that confuses the reason why the court's supervisory jurisdiction over solicitors exists with the scope of the court's powers when it is engaged. The reason for the jurisdiction is indeed the court's interest in controlling its officers. It does not follow that the court, in the exercise of the jurisdiction, cannot make orders against the body corporate through which the solicitor practices. On the law as stated by the courts below, if a solicitor practicing in a general partnership gives an undertaking on behalf of his firm, then it can be enforced against him and his partners under the court's inherent jurisdiction. But if the solicitor gives the undertaking on behalf of the authorised body corporate through which he practices, the supervisory jurisdiction cannot be invoked at all to enforce the undertaking. I submit that the scope of the inherent jurisdiction, as it applies to solicitors' undertakings, does not lack the coherence and the unity implied by the decisions of the courts below. So far as Mr. Parker is concerned, and this is issue 3, I submit that the courts below have confused questions of contract and agency with the question of conduct. Mr. Parker was not contractually responsible for the undertaking he gave on behalf of his firm, but as a matter of conduct, he is professionally responsible for seeing it performed. The court, under its inherent jurisdiction, I submit, has as much jurisdiction over Mr. Parker as if he gave the undertaking on his own behalf. As to issue 4, which assumes the inherent jurisdiction is engaged, I submit that a solicitor cannot set up the fact that, as the Court of Appeal has held, the undertaking was unreasonable by reference to the parties' interests as a reason for not honouring a solicitor's undertaking. Issues 5 and 6 concern the restraint of trade doctrine, which this court has, of course, considered on 2 occasions very recently. We are concerned in this case with how the doctrine should be applied in a case that involves 2 important features. First, Harcus Sinclair freely agreed the restraint. It had no disadvantage in bargaining power. A firm of solicitors can be taken, we say, to understand its own interests and know whether an undertaking is a proper one for it to give or not. The judge found, after a careful review of the circumstances surrounding the parties' agreement, that the undertaking made perfect commercial sense, that it was reasonable as between the parties, and not contrary to the public interest. See paragraphs 272, 316 to 317, and 321 to 323 of his judgment. But the Court of Appeal overturned the judge despite saying that it could be said that Harcus Sinclair was the stronger party. See paragraph 87 of the Court of Appeal's judgment. The Court of Appeal described the appellant, your lawyers, as, quote, a relatively small company offering the services of solicitor, see paragraph 2. Your lawyers had approached Harcus Sinclair because it needed legal assistance with the group action it was preparing. See paragraphs 51 to 53 of the trial judge's judgment. But the Court of Appeal held the bargaining power of the parties was irrelevant on the facts of this case. See paragraph 87 of its judgment. I respectfully suggest that one might well struggle to find examples in the case law where the doctrine of restraint of trade has come to the rescue of a party who enjoyed equal bargaining power, let alone someone who might be seen as the stronger party. I submit that the doctrine of restraint of trade has been turned on its head by subjecting the undertaking to an exacting assessment of its reasonableness, which cannot be justified if the law is correctly applied to the judge's detailed and full findings of fact. To compound matters, we respectfully submit that the basis on which the Court of Appeal held that it could interfere with the judge's assessment of reasonableness of the undertaking proceeded on a misreading of the judge's judgment. The Court of Appeal held that the judgment failed, that the judge failed to assess the reasonableness of the undertaking as at the correct point in time, which is, of course, as at the time the agreement was concluded. On a fair reading of the judgment, we say he made no such obvious error. The second important feature, so far as the doctrine of restraint of trade is concerned, arises if the contractual restraint is also a solicitor's undertaking under issue 1. The principles that guide the application of the doctrine of restraint of trade strike a balance, as you know, between 2 competing public policies. freedom to trade and freedom of contract. But what if a third aspect of public policy is in play, which supports the recognition and enforcement of the restraint? I submit that the public interest in solicitors complying with their undertakings and in maintaining public trust outweighs any consideration of policy that in an ordinary case might arise from the unreasonableness of the restraint as between the parties. As Lord Bingham said in Bolton and the Law Society, the profession's most valuable asset is its collective reputation and the confidence it inspires. See paragraph 727 of the bundle. As you know, as matters presently stand, Your Lawyers has no effective remedy for a serious breach of an agreement between two firms of solicitors. It has made a complaint to the Solicitors Regulation Authority, which has put the matter on hold pending the outcome of these proceedings. It's common ground, we understand, that neither the regulator nor the Solicitors Disciplinary Tribunal could award compensation or grant injunctions to enforce an undertaking. Having said that by way of introduction, my plan is as follows. I'm going to make some points regarding the non-disclosure agreement and the judge's findings of fact, insofar as they are relevant to the points of law in the appeal. Then I will take you to what we say are the most important cases on the enforcement of solicitors' undertakings under the court's inherent jurisdiction. I think I've whittled it down to 5 or 6. I will then make my submissions on the agreed issues. I intend to deal with the issues concerning the supervisory jurisdiction by about lunchtime, and then restraint of trade until 3:30. But that is a flexible plan, and of course there is some overlap, as is clear from the cases, between the two groups of issues. Turning then to the non-disclosure agreement and the judge's findings of fact. Would the court please go to the NDA, as we have been calling it, at page 338 of the bundle. This is obviously fundamental to the restraint of trade issues. You see it's dated the 11th of April 2016. Harcus Sinclair is the recipient, Your Lawyers the discloser, and by clause 1, the discloser intends to disclose information, the confidential information, to the recipient, Harcus Sinclair, for the purpose of obtaining legal advice on behalf of claimants in a large group action, and that's defined as the purpose. The trial judge found at paragraph 268 that the large group action referred to in clause 1 was a group action that Your Lawyers was preparing against Volkswagen in respect of the use of devices to reduce diesel emissions during testing. And then back to the NDA, clause 2, the first sentence, the recipient undertakes not to use the confidential information for any purpose except the purpose, without first obtaining the written agreement of the discloser. And then we have the undertaking in dispute, sentence 2 as the judge called it. The recipient further undertakes not to accept instructions for or to act on behalf of any other group of claimants in the contemplated group action without the express permission of the discloser. You'll note that the word is undertakes, not shall or will. The meaning of undertaking and undertake is well understood in the profession. Although those words don't have to be used to create a solicitor's undertaking, where a solicitor does use them, it is evidence, at least, that the solicitor intends the recipient to rely on the promise as a solicitor's undertaking given by the solicitor in his capacity as such. And then clauses 3 contains a further undertaking to keep the confidential information secure, and it's not relevant to the argument. Clauses 4 to 6 qualify the undertakings concerning confidential information and are likewise not relevant to the argument. Clause 7 provides that the undertakings will continue in force for 6 years from the date of the agreement. And then over the page, we have the words on which everything hangs from the respondent's point of view. We have Mr. Parker signing for and behalf of Harcus Sinclair LLP, you see on the left-hand side. I would ask the court to note 3 points at this stage in relation to the contract to which the non-disclosure gave rise. First, the undertakings in clause 2 are only engaged if and when your lawyers discloses the confidential information concerning the contemplated group action. If no confidential information is disclosed, the undertakings are not engaged. That's implicit in the structure of the agreement. In other words, the non-disclosure agreement contains the terms of a unilateral contract, like the familiar example of a promise to pay someone £100 if they will walk from London to York. The agreement was that Harcus Sinclair undertook that if your lawyers disclose confidential information to it concerning the contemplated group action, then Harcus Sinclair would act in accordance with the undertakings in the NDA. This is important because the respondents repeatedly state in their case that your lawyers undertook no obligations under the NDA. See, for example, paragraphs 27, 79.2, 80, 84, and 89 of their case. It is a central plank in the respondent's argument that the undertaking was unreasonable as between the parties because there was an imbalance between the parties' obligations. This, we submit, is misconceived. It is true that your lawyers undertook no obligation to provide the confidential information, but equally, Harcus Sinclair undertook no obligation if the confidential information was not provided. It was the provision of the confidential information that engaged the undertakings in the non-disclosure agreement and which concluded the contract between the parties. The second point is that the undertakings in clause 2 and 3 are in fact the price that Harcus Sinclair agrees to pay in exchange for the confidential information. They are not ancillary or peripheral terms of the contract, as is often the case with restraints of trade, particularly in post-termination covenants in an employment context. They are at the heart of the bargain. They are the sort of term which the law can expect Harcus Sinclair would focus on before agreeing to the NDA. This is another important consideration when we come to consider the restraint of trade issue. The third point is that Mr. Parker knew precisely what confidential information he would be receiving in exchange for his undertakings, because unbeknown to your lawyers, the proposed funder, Therion, had sent it already to Mr. Parker on the 8th of April, 3 days before he signed the NDA. See paragraphs 56 to 57 of the judge's information. The confidential information has been termed the litigation pack in this case. Its contents are listed out at paragraphs 54 of the judgment. It included counsel's advices and work product that your lawyers had funded out of their own pockets. Mr. Parker read the documents, notwithstanding that many of them were confidential and in some cases privileged. See paragraph 62 of the judgment. The point is this: Mr. Parker and Harcus Sinclair were in the best possible position to assess whether this was a good bargain when they agreed to it. Both parties appear to recognise that the judge's findings of fact are important to the points of law before the court, but there are differences of emphasis in the way the parties seek to present those findings. Compare paragraph 5 of our case with paragraph 4 of the respondent's case. It is necessary to clarify 4 points on the facts. First, the respondents at paragraph 4.3 of their case we respectfully suggest, risk obscuring the clarity of the judge's findings regarding Harcus Sinclair's knowledge and acceptance of the undertaking. These are, of course, important to the restraint of trade issue. The judge found in terms at paragraph 67 to 74 and 380 of his judgment that Ms. Morrissey, a senior solicitor at Harcus Sinclair, understood what the undertaking meant, that she considered it was an acceptable undertaking for Harcus Sinclair to give. Mr. Parker had asked her to review a draft of the NDA because, you may recall, she was familiar with their use between solicitors in the context of group actions. Ms. Morrissey considered the draft, she made some amendments to it, but she did not amend the undertaking. It's not disputed, as I understand it, that Ms. Morrissey's knowledge is attributable to Harcus Sinclair on orthodox principles of attribution. As far as Mr. Parker is concerned, the judge found that he was content to sign the NDA without reading it or giving it any thought. But importantly, Harcus Sinclair does not dispute that Mr. Parker had authority to give the undertaking. The second point on the facts is that at paragraph 4.4 of their case, the respondent seek to characterise Mr. Parker's and Harcus Sinclair's failure to honour the undertakings as innocent. They suggest that your lawyers accepted this during oral argument in the Court of Appeal. They developed this into a submission at paragraph 57 of their case that Mr. Parker's conduct did not meet the threshold of inexcusability required to warrant the court's intervention in the exercise of supervisory jurisdiction. It is not correct that your lawyers acknowledged in the Court of Appeal that the breach was innocent, and the transcript references which Harcus Sinclair to give to support the proposition, if you do look at them, don't support it. What your lawyers acknowledged in the Court of Appeal was that the judge had acquitted Mr. Parker of any intention to deceive your lawyers in relation to his undisclosed dealings with Slater and Gordon. It did not accept that Harcus Sinclair and Mr. Parker were blameless so far as the breach of the undertaking was concerned. The relevant findings concerning the breach are as follows as regards the question of innocence. First, when the dispute between the parties broke out in early January 2017, and Mr. Joel of your lawyers drew Mr. Parker's attention to the undertaking, Mr. Parker refused to acknowledge the undertaking and its implications. He carried on assembling his group action regardless, including issuing a press release advertising Harcus Sinclair UK Limited as the firm that would be the lead solicitor in the emissions litigation. This is set out at paragraphs 162 to 165 of the judgment. Secondly, by the time of the trial, Harcus Sinclair UK Limited and Slater and Gordon had assembled a group of some 43,000 claimants. And of course, you've already seen the judge and the Court of Appeal agreed that the meaning of the undertaking was clear and unambiguous. As we'll see when we go through the authorities, the courts do not require evidence of moral turpitude before they will enforce solicitors' undertakings, but on any view, we submit the breach of the undertaking, if it's enforceable, was serious. The third point on the facts concerns the burden imposed by the undertaking, and this may be relevant to the restraint of trade issue. At paragraph 4.2 of their case, the respondent suggests that the undertaking impacted on client choice and on the ability of Harcus Sinclair to earn professional fees. They say that the gravity of the impact can be illustrated by the fact that by the time of the judgment, some 43,000 clients had chosen to instruct them. They appear to rely on this to challenge the judge's finding that the undertaking was not contrary to the public interest. But this is to adopt the wrong perspective. Insofar as the likely effect of the undertaking is relevant to the question of restraint of trade, it must be assessed as at the date of the NDA on the assumption that the undertaking will be honoured, not on the assumption that it will be breached. And as the judge noted at paragraphs 322 to 324 of his judgment, the restraint was very modest indeed. The reason that the undertaking has had serious consequences for Harcus Sinclair and Mr. Parker is because Mr. Parker did not read the NDA, and when the undertaking was drawn to his attention in early January 2017, he ploughed on regardless in the assembling and advertising of his group action. When the judge came to consider whether an injunction should be granted, he carefully considered the impact that an injunction would have on Harcus Sinclair and its clients. See paragraphs 461 to 467 and 472 of the judgment. He concluded that the clients would not suffer because Slater and Gordon were already acting for them, and Slater and Gordon are a very experienced firm in the field of group litigation and will continue to act for them. See paragraphs 461 to 462 of the judgment. And as regards Harcus Sinclair, the judge saw no reason why they should not be held to their bargain. Harcus Sinclair did not appeal against the judge's exercise of discretion in relation to the granting of the injunction, so that is not an issue in this court. The fourth point on the facts concerns the judge's finding that the action commenced by Harcus Sinclair on behalf of its own group in October 2016 derived from its own work and the work of its counsel. It was not the product in any relevant sense, said the judge, of any confidential information disclosed to Harcus Sinclair by your lawyers. See paragraphs 401 to 402 and 405 of the judgment. The basis of that finding was that during the informal period of collaboration, Harcus Sinclair had worked up its own group claim, just as any lawyer who receives a draft advice or draft pleadings prepared by another lawyer should read all the materials but form his own or her own view. The judge's finding on this aspect of the case should not obscure the findings to the effect that the confidential information gave Harcus Sinclair insight into the merits and viability of bringing a group action. The relevant paragraphs of the judgment are 48, 61, and 313. And as the judge found at paragraph 272, the undertaking served to protect your lawyers against the risk that Harcus Sinclair would exploit the insight gained from the confidential information and collaboration by setting up its own group of claimants in the group action. I turn then to the law relating to solicitors' undertakings. I suggest that to determine the nature, scope, and limits of the court's inherent jurisdiction over solicitors, it is instructive to see how the judges have shaped the jurisdiction to deal with particular problems before them. You'll see as we go through the cases that to some extent the question of the scope of the jurisdiction has been considered by judges as a matter of practice and custom. Solicitors' undertakings have not been considered at the highest level in the modern era, so far as we've been able to ascertain. We have set out the relevant principles and rules derived from the case law and the statutory scheme at paragraphs 8 to 22 of our case. That section is fully referenced to the authorities and the rules, and the respondents have acknowledged in paragraph 5 of their case that it's broadly accurate, subject to some qualifications that they enter. May I also please give the court the reference to a very helpful summary in Cordery on legal services, which we didn't mention in our skeleton, but it's in the bundle. It provides an overview of the jurisdiction. You've got it at page 2161. It's only about 4 or 5 pages long. Now, since issues 1 to 4 concern different aspects of the same topic, the enforcement of solicitors' undertakings, I propose to take the court chronologically through what we say are the key authorities on solicitors' undertakings, that are relevant for what you have to decide, so you can see how the jurisprudence has developed. And as we go through the cases, I will relate them to the issues. I'll then be able to make my submissions on the issues concerning the supervisory jurisdiction relatively shortly. By way of overview, the essential principles on which solicitors' undertakings are enforced under the inherent jurisdiction were settled in the 19th and early 20th century. The judgment of Mr. Justice Hamilton, who is perhaps better known to us as the Law Lord Lord Sumner or Viscount Sumner in United Mining and Becker, contains a clear exposition of the principles laid down in the early cases. After that case was decided in 1910, there was very little by way of reported cases on solicitors' undertakings until the 1970s and 80s. In the meantime, the House of Lords considered the court's inherent supervisory jurisdiction over solicitors in Myers and Allman in 1940, particularly in relation to the power to award costs. The Court of Appeal was then called upon to consider undertakings in a series of cases from the 1970s, which applied or approved the old authorities, which we're going to see. The authorities I'm going to take you to establish, I submit, three main points. That these are all mentioned in our case between paragraphs 8 and 22. One, all promises made by a solicitor in his capacity as such fall within the supervisory jurisdiction. Paragraph 13 of our case. You will see the early cases use the old-fashioned phrase in the character of attorney, but the meaning is the same. Two, determining the capacity in which a solicitor was acting involves a factual assessment of whether the solicitor was acting as a solicitor when he gave the undertaking. Paragraph 18 of our case. Three, although the question is one of discretion, the court, in the exercise of its supervisory jurisdiction, takes a strict approach to the enforcement of solicitors' undertakings in order to maintain proper professional standards. Paragraph 19 of our case. If we could start then, please, with Re Greaves, a decision of the King's Bench, which the court will find at page 1129 of the bundle. I don't know if anyone's working with paper. It's tab 56. Probably best if I give you the tab number.
No. Mr. Coleman, I forgot to mention to you this morning at our pre-meeting that we're all working off electronic bundles.
Yeah.
We don't have hard bundles.
I've got the electronic.
I see that Mr. Crowe is working off hard bundles, so he will need the hard reference.
Yes. Is it helpful if I give you the tab number for the authorities, or just the page number?
For the court,
yes.
All we need is the page number.
I'm grateful, my lord.
But Mr. Crowe is going to need the tab, I think.
Yes, I'll do both. Tab 56. Tab 56, page 1129. And this case, the layout of the report's unusual because it's actually reported as a footnote to Evans and Duncan, which you can see in the top left-hand corner. And in the report of that case, cited in Re Greaves, and there's a footnote referring to Re Greaves, and it's Re Greaves which has been passed down to us as the important authority, but the report runs across the bottom of the page from 1129 to 1131. It's a decision in the King's Bench. The case establishes that the fact that an undertaking is not enforceable in contract is not necessarily a defence to an application to enforce it. As we'll come on to see in the later authorities, the existence of a defence at law may be a factor that the court takes into account when deciding whether in its discretion to enforce the undertaking. Mr. Greaves was an attorney of the King's Bench. he had compromised an action in the Court of Common Pleas and had agreed orally to give the plaintiff promissory notes for his debt and costs, and he failed to provide the promissory notes. The King's Bench rejected the attorney's argument based on the statute of frauds for reasons which we can see from the short note of the judgment, which we've got at the bottom of page 1130. Probably we don't know who the judge is, but even supposing the undertaking to be void by the statute of frauds, this court may nevertheless exercise a summary jurisdiction over one of its own officers, an attorney of the court. The undertaking was given by the party in his character of attorney, and in that character, the court may compel him to perform it. An attorney is cognisant of the law, and if he give an undertaking which he must know to be void, he shall not be allowed to take advantage of his own wrong and say that the undertaking cannot be enforced. Looking forwards, the Court of Appeal cited this case with approval in Udall and Capri, which we'll come to. The relevant page for the electronic bundle is page 1957, tab 96, Udall and Capri. We'll come to it. I submit that those observations in that judgment apply to the undertaking given by Mr. Parker on behalf of Harcus Sinclair, even if one assumes that the Court of Appeal was correct to hold that it was unenforceable in contract under the restraint of trade doctrine. Mr. Parker and Harcus Sinclair can be taken to be cognizant of the law. We come then to two decisions of Mr. Justice Coleridge, decided in 1845, which have been influential in the development of the jurisdiction. Firstly, In re Hilliard, tab 62A, page 2710. There was a slight problem with the copying, so you've also got in a supplemental bundle, page 104, but if you haven't yet discovered the delights of the supplemental bundle, the main bundle will be sufficient. In this case, explains, it was heard in the practice court of the King's Bench. As we've explained in footnote 28 of our case, the practice court dealt with issues of legal practice, as one would expect. And this case explains that the reason that the court enforces undertakings, notwithstanding that a solicitor may have a defence at law, is to secure proper conduct by the court's officers in all matters that they undertake to perform or see performed. The plaintiff had agreed to compromise his claim on the basis of an undertaking from the defendant's attorney, Mr. Hilliard. As in Greaves, Mr. Hilliard resisted the enforcement of the undertaking on the basis that it was void under the statute of frauds. Mr. Justice Coleridge referred to Greaves and other cases that had followed it, and we can pick up the judgment about halfway down the right-hand column, where he said this: against these cases, so that's Greaves and others, no authority was cited. And the argument used was founded entirely on the fact of the contract being void. But it seems to me that the court does not interfere against one of its own officers merely with a view of enforcing in a more speedy and less expensive mode contracts in which actions might be brought, but does so with a view of securing honesty in the conduct of its officers in all such matters as they undertake to perform or see performed, when employed as such or because they are such officers. The principle applies equally whether the undertaking be to appear, to accept declaration or other proceeding in the course of the cause, or to pay the debt and costs. The interference is not so much between party and party to settle disputed rights, as criminally to punish misconduct or disobedience in its officers. In this view, the objection relied on does not apply. I have no desire to restrain the jurisdiction of the court, as to the undertakings of its officers on any such ground as the present. They are very often most beneficially made for both parties in a cause, and there would be great injustice in allowing the attorney to get free from them after the party has forgone the advantage or paid the price which was the consideration of the undertaking. While on the other hand, there is no hardship on the attorney in enforcing them, for he's never compelled to enter into them. If he does, he should secure himself by an arrangement with his client, as he must be taken to know the legal consequences of his own act. In looking forwards to subsequent developments, Mr. Justice Hamilton in United Mining and Finance and Becker held that honesty in this context, that was the word used by Mr. Justice Coleridge, is understood broadly as referring to proper professional conduct. And we'll come on to see where that was said. The page reference from Mr. Justice Hamilton it's tab 98, page 1991, but we'll come on to it. So that was a case concerning undertakings in relation to jurisdiction, to court proceedings. But in the next case of Mr. Justice Coleridge, the question arose as to whether they could be enforced in a wider context. It's the case of In Re G, tab 52, page 1082. And this case decided that the jurisdiction was not limited to undertakings given in relation to court proceedings or in relation to clients. It illustrates, I submit, that the courts in the early decisions that shaped the exercise of the jurisdiction in respect of solicitors' undertakings resisted attempts to limit what may qualify as an undertaking. All undertakings given in the capacity of solicitor are covered. Mr. G, the attorney in question, was acting in relation to a conveyance of land, and he undertook to pay the costs of the attorney acting for the mortgagee. Those are the simple facts. He resisted the application to enforce the undertaking, and if we can pick up the argument advanced on Mr. G's behalf, about 8 lines or so from the bottom of page 1084. This is counsel's argument. The sentence beginning, "This is not the case of an undertaking." About 8 lines from the bottom of 1084. "This is not the case of an undertaking between attorney and client, nor is it an undertaking in a cause or suit in which the one attorney was acting for the plaintiff and the other for the defendant, but it is a promise by Mr. G to pay the costs incurred by another party and for which he could receive no benefit. There is no instance of an application by one attorney to compel another to perform an engagement not given in any action or suit. This agreement is clearly within the statute of frauds." And Mr. Justice Coleridge rejected the argument in the following terms. The question here is, was this an undertaking by Mr. G in his character of attorney? And I think upon the whole facts of the case that it was, that this rule must therefore be made absolute. Upon the facts disclosed in the affidavits, there can be no doubt that credit was given to him because he was the attorney of the mortgagor. It is said that there is a distinction between the case of an attorney who may be called upon by his client to perform his undertaking and that of an attorney who is not acting in any suit or action and who is called upon by the attorney of another party. But I see no foundation for this distinction. I think the two cases stand upon the same ground. The question in either case is, has the undertaking which it is sought to enforce been given by the attorney in his character of attorney in the transaction in dispute? 2 points I make in relation to that. Firstly, that remains the question today. And secondly, it is essentially a question of fact. As you can see from the judge's discussion. My Lord, Lord Burrows is
Yes, I'm sure you're going to amplify this further, but I would be helped by some examination as to precisely what's meant by acting in the character of a solicitor or attorney. So I think one example given somewhere, I can't now remember where it was of the solicitor who takes out a lease
Yes.
for the premises, and in the context of that is giving an undertaking. One might also think of, a solicitor organising a networking event.
Yes.
And in, one might say, the capacity of a solicitor, might one organises for a catering company to come in. So,
Yes.
I mean, I'm sure you're going to deal with this, but I just wanted to flag that I
Yes.
just need clarification about what's meant.
Yes, but I was going to come on to it, but can I provide the clarification now? One doesn't need to seek to define it or necessarily gloss it, but the essential inquiry is, what role was the solicitor performing when he or she gave the undertaking? Was he or she performing the role of solicitor, or were they performing the role of ordinary citizen? So when a solicitor rents a photocopier or signs a lease, that, I suggest, as a matter of fact, is done in the role of ordinary solicitor, or ordinary citizen, or layman, which was the term used by Mr. Justice Hamilton in the United Mining and Becker cases, we'll see. And of course, there may be difficult cases at the boundary, but that is the essential question. I'll amplify that in due course, my lord. The next case to which I wish to draw your attention is the decision of Mr. Justice Williams and In re Fairfawn, decided in 1846. Rather than go to it, may I remind you where we refer to it in our case? It's paragraph 18. In that case, Mr. Justice Williams said that any question of capacity in which a solicitor gives an undertaking is a question of fact. That, I submit, has already been established by the cases we look at. It's a very short report, but we don't need to go to it now. You have the reference at paragraph 18 of my case, and you'll see it referred to in the case we go to now, which is United Mining and Becker, Mr. Justice Hamilton, tab 98, page 1982, please. This judgment contains a very clear exposition of the jurisprudence derived from the early modern cases, some of which we've looked at. The Court of Appeal cited it with approval when it came to summarize the relevant principles in various cases in the 70s and 80s. Mr. Justice Hamilton affirmed the broad nature of the court's jurisdiction in respect of solicitors' undertakings. The jurisdiction covers all undertakings given by a solicitor in his capacity as such, and the jurisdiction does not depend on showing moral turpitude. The facts in very brief outline were that a solicitor acting for one party in a commercial transaction gave an undertaking to the other party to return checks if his client did not agree more favorable terms within a certain period. The solicitor, Mr. Becker, failed to honour the undertaking as he was concerned that he would be acting contrary to his client's interests if he returned the checks. And the holding is clearly set out in the head note. The court has jurisdiction on the application by a person to whom a solicitor gives an undertaking in his capacity as a solicitor to exercise its summary procedure to compel the solicitor to carry out the undertaking, even though the applicant is not the client of the solicitor and the undertaking was not given in the course of legal proceedings, and there is no suggestion of dishonourable or discreditable conduct. And then if we could go please to the page 1989. Perhaps can I just ask you for your notes to note at 1985 that these points were fully argued by counsel as to the scope of the jurisdiction. Mr. Montague Lush, King's Counsel. And then if we go to page 1989, picking it up about 2/3 of the way down, you see a reference to Cordery on solicitors, which the judge said summarizes the law conveniently and points out that the court will summarily enforce undertakings given by a solicitor in that character, adding it matters not that his services are gratuitous or that the undertaking is given after judgment, or even that it's not given in an action, but in a mere mortgage or loan transaction. But the solicitor must be acting professionally. And then at the bottom of the page and over the page, the judge cited the decisions of Mr. Justice Coleridge that we've just been looking at in G and Hilliard, and he quotes extensively from Hilliard. And then if we could go please to page 1991, at the second line, 1991, Mr. Justice Hamilton says that although Mr. Justice Coleridge places the jurisdiction of terms upon the ground that it is exercised with the view to securing honesty in the conduct of its officers, honesty in that regard is not meant by him to be purely a moral quality, but is, as is evident from the decision in G and other cases, a term applicable to the proper and professional observation of undertakings professionally given. The conduct which is required of solicitors is to this extent perhaps raised to a higher standard than the conduct required of ordinary men, and that it is subject to the special control which a court exercises over officers, so that in certain cases they may be called upon summarily to perform their undertakings, even where the contention that they are not liable to perform them is entirely free from any taint of moral misconduct. And then a few lines down in the middle of the page, you see he cites In re Fairthorne, the case I said I wasn't going to take you to, for the proposition that the question, therefore, as in every other case, is whether the attorney was acting in that character when he gave the undertaking. And then if we go over the page, please, 1992, he goes on to explain why he cannot accept that the jurisdiction is limited in the way that the solicitor had contended, and we can pick up the judgment in the middle of 192, if you can see the sentence beginning, were it otherwise, and the reference to G. Were it otherwise, it does not appear to me that I can refuse to follow In re G, In re Fairthorne, and In re Pass. The expression used in the judgments in those cases was in his capacity as a solicitor, or its equivalent must be a reference to in the character of the attorney, this the more old-fashioned language we've seen. That is an expression which is no doubt not very easy to define with any extreme precision, but I think that in order that the jurisdiction may arise, proof by the applicant is involved, if he is put to proof, that the solicitor was given by the solicitor, that the undertaking was given by the solicitor in his capacity as a solicitor, and that the event has happened upon which it ought to be performed. Pausing there, my lords and my lady, that was a burden which the trial judge held your lawyers had discharged. Then at the bottom of the page, still 1992, the judge says that it's always competent to the solicitor to urge that there are grounds upon which the court should refuse to exercise its discretion in the matter. And then over the page, 1993, about 8 lines down, beginning whatever that expression may mean. That's a reference to the expression in the capacity of a solicitor. He says, whatever that expression may mean, I think it must at least go as far as this: that when a solicitor in the course of business, which he's conducting for clients with third parties in the way of his profession, gives an undertaking to those third parties, incidental to those negotiations, that undertaking is one which is given in his capacity as a solicitor and not as mere layman undertaking the office of a stakeholder or guaranteeing the payment of money. And then he continues to describe the part that solicitors play in commercial negotiations, which they facilitate by giving undertakings because they're deemed to be trustworthy. And then if we can pick it up at the bottom of the page, please, about 6 lines from the bottom, the judge rejects the suggestion that the applicant should have commenced an action, an ordinary action. He says, I think when a solicitor gives an undertaking of this character, the parties to whom the undertaking is given are under the practice entitled to resort to this ready mode of determining disputes, which the solicitor is entitled to raise, and to obtain an order for the payment if the solicitor fails. That is an important aspect of the jurisdiction. It serves to provide a speedy and effective remedy to the recipient of the undertaking. As I've indicated, Mr. Justice Hamilton's judgment appears to have settled the important issues that arise in relation to undertakings for the next 60 years or so. But in the meantime, there was the decision of the House of Lords in Myers and Allman, and it is convenient to consider that case as part of this chronological survey of the cases, although it doesn't concern undertakings, because the discussion that it contains of the origins of the inherent jurisdiction over solicitors is referred to in the subsequent cases, and indeed it is foundational to our understanding of the supervisory jurisdiction generally. Although not about an undertaking, as I'll come on to explain, it does cast light on how the issues in this case are to be decided. Perhaps if we can turn it up, please. It's tab 72, page 1375. The case is perhaps best known today for the guidance that it gives on solicitors' duties in relation to disclosure. But the other main issue in the case was whether the court's power to order a solicitor to pay the opposing party's costs under the inherent supervisory jurisdiction could be exercised when the misconduct was committed not by the solicitor, but by his managing clerk. And we can see this from the first part of the head note. The jurisdiction of the court to order a solicitor to pay the costs of proceedings is not limited to cases where he personally has been guilty of misconduct, but extends to a case where his managing clerk, to whom he has entrusted the necessary work, is guilty of misconduct, as, for example, in the preparation and filing of incorrect and inadequate affidavits or documents. Before I take you to the relevant parts of the speeches of Lord Atkin and Lord Wright, let me explain why I say this case provides helpful guidance for our case. The House of Lords did not have to grapple with the question whether the court's approach to Mr. Allman should have been any different if he'd been practicing through a company, which was not permitted in 1940. On the reasoning of the courts of the present case, it would seem that Mr. Allman would have taken himself outside the court's supervisory jurisdiction. That, I suggest, is difficult to reconcile with the robust descriptions of the inherent jurisdiction in respect of solicitors in the speeches in this case. What's more, the House of Lords in this case did not allow the solicitor to hide behind his clerk. The jurisdiction, though personal, was sufficiently flexible to render Mr. Allman professionally responsible for his clerk's conduct. Conceptually, that is not very different from what we ask this court to do under issue 3, to recognise that Mr. Parker is professionally responsible for his part in Harcus Sinclair's failure to perform the undertaking. If we can go, please, to page 1395, the speech of Lord Atkin. We've got a passage which recurs in later decisions explaining the history of the jurisdiction. Top of the page, from time immemorial, judges have exercised over solicitors, using that phrase in its now extended form.
The page again, please.
Sorry, my lord, it's 1395.
Thank you. Thank you.
From time immemorial, top of the page, judges have exercised over solicitors a disciplinary jurisdiction in cases of misconduct. At times, the misconduct is associated with the conduct of litigation preceding the court itself. Rules are disobeyed, false statements are made to the court or to the parties, by which the course of justice is either perverted or delayed. The duty owed to the court to conduct litigation before it with due propriety is owed by the solicitors for the respective parties, whether they be carrying on the profession alone or as a firm. They cannot evade the consequences of breach of duty by showing that the performance of the particular duty of which breach is alleged was delegated to the solicitor, delegated to a clerk. And then if we can skip 6 lines or so and pick it up at the sentence, but as far as the interest of the court, but as far as the interest of the court and the other litigants are concerned, it is a matter of no moment whether the work is actually done by the solicitor on record or his servant or agent. If the court is deceived or the litigant is improperly delayed or put to unnecessary expense, the solicitor on record will be held responsible and be admonished or visited with such pecuniary penalty as the court thinks necessary in the circumstances of the case. I submit that a similar observation could be made in relation to solicitors' undertakings. As far as someone who has relied on a solicitor's undertaking is concerned, it is of no moment to them whether the solicitor gave the undertaking on his own behalf or on behalf of his firm. Remembering, of course, that many recipients of undertakings are not lawyers and will not perceive necessarily, if the Court of Appeal's decision is correct, the distinction between an undertaking given by the solicitor and one given on behalf of the firm. Lord Atkin's discussion regarding the jurisdiction to order a solicitor to pay wasted costs continues to the end of page 1396. In the interest of time, I won't ask you to look at it now, but I would invite you to read it as you consider your judgment. Although it concerns wasted costs, it does provide an indication of the robust nature of the jurisdiction. Can we turn now, please, to the speech of Lord Wright at page 1410. It contains another helpful overview of the inherent jurisdiction over solicitors, which is cited in subsequent cases on undertakings. Again, I won't read it all, but I'll draw your attention to the passage, first of all, in the middle of page 1410, where Lord Wright says that in order to deal with a point of law decided by the Court of Appeal, it's necessary to explain briefly the nature of the jurisdiction of the court which the appellant invoked. A solicitor, or in former days a solicitor or an attorney, was long ago held to be an officer of the court on the roll of which he was entered, and as such be the subject of the discipline of that court. That, of course, is the basis, my lords and my lady, of the supervisory jurisdiction, and it gives rise to the issue as to whether it can be exercised in any way to make an order against Harcus Sinclair in circumstances where Harcus Sinclair is not an officer of the court. And then there is quite an extensive discussion in Lord Wright's speech through to the end of page 1412 about the nature of the supervisory jurisdiction so far as it relates to costs. Again, in the interest of time, I won't ask you to read it all now, but I do invite you to consider it in due course, because it provides another indication of the robust character of the jurisdiction generally. If I can take you, please, to some specific passages that I should mention. First of all, in paragraph 40 of their case, the respondents point out that about 4 lines into page 1411, Lord Wright said that the court would, whether the court would now entertain an application to strike a solicitor off the roll or to suspend him instead of leaving the matter to the disciplinary committee may be doubted. As we pointed out in footnote 2 of our case, the jurisdiction to strike off a solicitor is still used, albeit extremely rarely. It was exercised by Mr. Justice Neuberger in Penner in the Law Society when he struck off a solicitor. And the reference for Penner is page 1572. As I say, we mention it in footnote 2 of our case. And then at the bottom of the page, about 5 lines from the bottom of page 1411, Lord Wright says that the summary jurisdiction thus involves a discretion both as to procedure and to substantive relief. So it is a discretionary procedure, both in substance, discretionary jurisdiction, both in substance and as to the procedure. And then over the page, I want to draw you to your attention to a statement which is picked up in the later authorities. It's about 5 lines from the bottom of the very long paragraph, 3/4 of the way down page 1412, where we have the sentence, "The jurisdiction is not merely punitive but compensatory." Lord Wright speaking there of the jurisdiction as regards wasted costs, that it applies more generally. I submit that Myers and Ellman is a vivid illustration of the way in which the courts have exercised the jurisdiction respective solicitors in a practical way, free of any technical rules. The next significant decision concerning undertakings is that of the Court of Appeal in Jeffrey, Silver and Drake and Baines, tab 53, page 1087.
Sorry, number again, please.
1087, my lord.
Thank you.
The Court of Appeal affirmed the test of capacity for determining whether an undertaking is subject to the inherent jurisdiction of the court. However, it held that the undertaking in that case was not given in the solicitor's capacity as such. The solicitor undertook to repay a loan with interest. The undertaking did not relate to any fund that the solicitor held on trust. It was entirely unrelated to legal work. And as with all these cases, the decision turned on the evaluation of the facts, although the Court of Appeal did overturn the judge's evaluation of the facts in that case on the basis that the loan did not have any connection, in essence, with solicitor work. And the judgment of Lord Denning, if we could pick it up, please, at page 1093, in the middle of the page, you can see at letters D to E, he summarizes the supervisory jurisdiction by reference to the cases we've seen, Myers and Ellman and United Mining and Becker. And at E, he affirms the test of whether the undertaking was provided in the capacity of solicitor. And then at letter F, he says that the summary jurisdiction means, however, that the solicitor is deprived of the advantages which ordinarily avail a defendant on a trial. There are no pleadings, no discovery, and no oral evidence save by leave. The jurisdiction should therefore only be exercised in a clear case. Now, those remarks may reflect the historical foundations of a jurisdiction that could be invoked without formal process of action or indictment. However, we've already seen in Myers and Ellman, Lord Wright said that the court has a discretion as to procedure. And in Fox and Bannister, which we'll come on to, the Court of Appeal, comprising Lord Justice Nichols and Sir John Donaldson, the Master of the Rolls, held that an application to enforce an undertaking, on such an application, the court may adopt whatever procedure it considers appropriate, including pleadings, disclosure, oral evidence, and cross-examination. And that has become part of the established approach. I would ask the court to note that at paragraph 38 of their case, the respondents quote this passage from Lord Denning's judgment as if it represented the current view of the jurisdiction. It's not clear at what point they seek to make, but I'll deal with it in closing if I have to. And then at the bottom of the page, from letter G, we've got Lord Denning's treatment of the facts, which I don't wish to read out to you now, but the essential point was that this was a bare undertaking to repay money, as he reasons over the page. And we see this is a recurring feature in the cases where a solicitor has been held not to be acting in his capacity as a solicitor. The cases tend to involve a bare undertaking to pay money. Solicitors do not practice in order to make loans. Lord Justice Widgery and Lord Justice McGaw gave concurring judgments to the same effect. Can I ask you please to, at page 1094, to look at letter G. This is the judgment of Lord Justice Widgery. He said that the first requirement of the exercise of the jurisdiction, as Lord Denning has pointed out, is that the undertaking in question must have been given by the solicitor in the course of his activities as a solicitor, must be given by him professionally as a solicitor, and not in his personal capacity. The reason for that is clear enough, because a remedy of this kind is intended primarily to discipline the officers of the court, to ensure the honesty of those officers. The court is thus concerned only with their activities as solicitors, and anything done by a solicitor in its private capacity is outside this jurisdiction. That passage touches on the question raised by my Lord Burrows earlier. Well, that finishes that case, and I note the time, it's 11:45.
We'll take a short break. In that case, 5 minutes, please.
I'm
Thank you,
grateful.
Mr. Coleman.
Thank you.
Mr. Coleman, Lady Arden has a question for you.
Thank you, my lord.
Thank you very much, Lord James. Mr. Coleman, could I just put 2 points to you, arising out of the passage in Cordery, to which you referred us, and this case which we have just read. Firstly, at page 2163 of the bundle, about a quarter of the way down the page, Cordery makes the point that it's difficult to reconcile the approach in Silver, with the SRA glossary, which gives an extended meaning of undertaking. And maybe we should have that in mind. And my second question is about the passage at the foot of the page, dealing with undertakings in partnerships, where it refers to the decision of the Court of Appeal. And I would like to ask you whether or not it is now a practice whereby solicitors will require undertakings from other solicitors and not from partnerships, whether that's become the practice as a result not simply of the decision in this case, but the earlier decision in Cannet Azubayev, so that they can be enforced by the process that you have been describing.
Yes, but on the second question, I don't know what impact this case has had on the practice. Certainly, anyone receiving an undertaking would be wise to ensure that it's given by a solicitor personally, but whether people are doing that or not, I do not know.
Well, if you're able to help us, that would be It would be interesting to know.
Yes.
Because one would have thought that it would now be the case that prudently people, especially in conveyancing, would look to other solicitors for undertakings.
Indeed, whether that would have an impact on, for example, insurance arrangements within firms, I don't know, but one could perhaps speculate that it could do.
Well, that's by the by. The third party's point of view, he still has the protection of getting the undertaking from an individual solicitor.
Yes, that's certainly an option, to get the undertaking from the individual solicitor. On the first point, there may be tension between what was held in Silver, Drake and Baines and the approach under the SRA Code of Conduct, because there may be circumstances where a solicitor makes it clear that he is giving his undertaking in his capacity as such. If, for example, he were to say to someone, I give you my word as a solicitor that I will repay the money, that could well have regulatory implications. And whether a court today would treat such a case in the way that the Court of Appeal did in the 1970s is perhaps an open question.
Do you need to go further on your submissions?
I don't, my lady. I don't, because we're not. I submit that we're not in that territory. We're well within the domain of solicitors' undertakings.
Thank you.
Can we then go next, please, to John Fox and Bannister, which we've got at tab 51, page 1074.
Sorry, the page again, please.
1074, my lord.
Thank you.
This case applies the established principles. It's a decision of the Court of Appeal with a panel of Sir John Donaldson, the Master of the Rolls, and Lord Justice Nichols, and it concerned an undertaking between solicitors. And it illustrates that the question of capacity in which a solicitor acts is to be approached broadly. The facts and outline were that Mr. Fox, a solicitor, was owed legal fees by his former client. Mr. Bannister, who was also a solicitor, was acting for the same client in a property transaction. Mr. Bannister held £18,000 for the client in his client account, and he gave an undertaking to Mr. Fox to the effect that he would retain the money until the disagreement between the client and Mr. Fox over legal fees had been sorted out. And for your note, you can see the terms of the undertaking at page 1076, B to E. But if we can focus perhaps on the issues of principle at page 1077, letters C to E, you can see that Lord Justice Nichols, whose judgment this is, directed himself in accordance with the principle that as officers of the court, solicitors are expected to abide by undertakings given by them professionally, citing the decision of Mr. Justice Hamilton in United Mining Finance and Becker. And he also noted at the end of the paragraph, letter D, that a solicitor may be ordered to make good the loss flowing from his failure to perform the undertaking. At letter G, you can see that the Court of Appeal considered that the commitment by Mr. Bannister was given in his capacity as solicitor, for it was in that capacity that he was holding the £18,000 in question. And then at page 1079, letters E to F, Lord Justice Nichols responds to the point raised by Lord Denning and the other judges in Silver and Drake and Baines regarding procedure. The key passage begins just above letter F down to the end of the paragraph. I won't read it out, but he makes the point, as we've already seen in Lord Wright's speech, that it is a flexible jurisdiction and the court can adopt such procedure as it considers appropriate. Perhaps if the court would read that passage to itself, ending with the words, in a clear case. And as you know, in this case, proceedings were commenced under Part 8 of the CPR and were directed to continue as if commenced under Part 7. There were pleadings, disclosure, and a trial with oral evidence. But on the judge's findings of fact as to the meaning of the undertaking, in our case, this was a clear case. Both courts concluded that the meaning of the undertaking was clear and unambiguous, subject, of course, to the question of restraint of trade, which is in issue. Sir John Donaldson agreed with Lord Justice Nichols, and he made some slightly more expansive observations about the procedure, responding directly to what Lord Denning had said. Could I ask you, please, simply to note that as something that you might read when you consider your judgment? It's the whole of page 1080 it repays reading. If we could turn next, please, to the further decision of the Court of Appeal later in the same year, 1988, Udall and Capri, which we've got at tab 96, page 1947. The value in this case lies not so much in its facts, but for any new principle, but for the helpful summary of the authorities and principles provided by Lord Justice Balcombe at pages 1956 to 1958, beginning at 1956D and going through to the top of 1958, the middle of 1958. Again, can I invite you to note this as something that you might read as you consider your judgment? If I could just focus on some new points. Firstly, at 1957 E, point 2, you see it stated that although the jurisdiction is compensatory and not punitive, it still retains a disciplinary slant. It's only available where the conduct of the solicitor is inexcusable and such as to merit reproof. He cites a decision of the Court of Appeal, including Lord Justice Denning, involving a question of wasted costs. That's Aaron, Thew and Reeves. But then at point 4, he says that failure to implement a solicitor's undertaking is prima facie to be regarded as misconduct on his part. And this is so even though he's not been guilty of dishonourable conduct, citing United Mining Finance and Becker. However, exceptionally, the solicitor may be able to give an explanation for his failure to honour his undertaking, which may enable the court to say that there's been no misconduct in the particular case. And then at point 5, there is citation of Inri Greaves, and it is said that factors such as the existence of a defence may be taken into account in deciding whether or not to exercise the discretion, and if so, what manner. That's the last sentence at point 5, 3 lines from the top. The respondents obviously rely upon that in this case in relation to the restraint of trade defence that they say they have at law. And then point 6, bottom 2 lines, in the case of an undertaking where there is no evidence that it is impossible to perform, the court will usually require the solicitor to do that which he's undertaken to do. So the established practice is to enforce an undertaking, at least where there's no evidence that it's impossible to perform. If it is impossible to perform, then compensation might be ordered in the discretion of the court. The judge in this case found that the undertaking was not impossible to perform, which is why he granted the injunction. Those are the key authorities on the nature of solicitors' undertakings and the court's approach in practice. to their enforcement. I should, however, draw your attention to a group of cases that have considered the application of the rules of agency to solicitors' undertakings to pay money in circumstances where the undertaking is unrelated to any professional service. We've seen an example in Silver, Drake and Baines. We have mentioned these cases in paragraph 18 of our case. I don't want to say anything about them at this stage. They are Hurst and Etherington, Ruparel and Arwen, and United Bank of Kuwait and Hamoud. In paragraphs 19 to 21 of their case, the respondents rely heavily on the judgment of Lord Justice Staunton in United Bank, Kuwait and Hamoud to support a restrictive approach to the question whether an undertaking is given in the solicitor's capacity as a solicitor. I'll respond to that argument when I come to reply. I simply make clear for now that the appellant does not accept that the judgment of Lord Justice Staunton supports a restrictive approach to the broad question whether an undertaking is given in the capacity of solicitor. But I think you'll understand my response better once you've heard Mr. Crowe make the argument. Turning briefly to the regulatory scheme, as we point out in paragraphs 21 to 22 of our case, the SRA's rules require solicitors to comply with their undertakings. Solicitors are generally are under a general professional duty to act with integrity and with complete trustworthiness. And Sir Thomas Bingham, as Master of the Rolls, succinctly summarised the professional standards expected of solicitors in Bolton and the Law Society, to which I've already referred. They must act with complete integrity and probity and complete trustworthiness. They must maintain the public trust. And one particular instance of those general duties is that they must comply with their undertakings. As I shall come on to submit under issues 4 and 5, it is our case that on the facts of this case, the public policy that solicitors act in a trustworthy way and maintain public trust outweighs any policy considerations that may arise under restraint of trade. Turning then to issue 1, is the undertaking an undertaking given by a solicitor acting in the capacity of a solicitor? As we've seen, the judges who have developed the supervisory jurisdiction did not find it necessary to seek to further define what is meant by acting in the capacity of solicitor. That is in keeping with a flexible jurisdiction which is not constrained by technical rules. It is a straightforward concept that does not require further definition or glossing, I suggest. The inquiry as to capacity focuses on the role that the solicitor was performing when he gave the undertaking. Was he acting as a solicitor, or was he acting in his private capacity as an ordinary citizen, or as a layman, as Mr. Justice Hamilton put it? If he was acting as a solicitor, then honouring the undertaking is a matter of professional conduct and standards, and the court has an interest under its supervisory jurisdiction in seeing that it's performed. If, on the other hand, it's unrelated to his role as solicitor, then it comes under his private affairs and falls under the court's supervisory jurisdiction. The respondents at paragraph 21.2 of their case give a good example of a solicitor's contractual obligations under a lease. There may be difficult cases at the boundary. Most of them will be able to be resolved on practical grounds. My Lord Borough's example of a solicitor's marking event, well, if a promise was made in that context, one might say it's connected to the solicitor's role, possibly, but undertakings are only enforced if reliance upon them is reasonable and depending on the facts, but may often be capable to dispose of a complaint about an undertaking on the basis that it couldn't really be taken as a promise intended to be that the solicitor intended to be held to in absolutely all circumstances. But those sorts of, my Lord,
Can you just help me, Mr. Coleman, with what you then say about Silver and Baines and some of these other cases? are you saying, well, that's just a question of fact and we don't need to go there? Or are you saying that they may be somewhat problematic? I mean, why in those cases where a solicitor is, as solicitor, receiving money, agreeing to repay, in what sense are they acting as a layperson?
Well, it may be that a different view on the facts was available, but certainly the reasoning of the Court of Appeal in that case is that solicitors are not in the business of lending money. I don't need to take a position on the correctness of that case on the facts for the purposes of my appeal, but one can see an argument that on the facts of that case, the solicitor gave the undertaking in the course of his work. One can simply see an argument that he was acting in his capacity as solicitor. But certainly that category of cases where a solicitor gives a bare undertaking to pay money unrelated to any transaction, as a matter of practice, certainly on the authorities, is treated as outside the jurisdiction. And this is a jurisdiction where practice is important. It helps to shape the boundaries. Now, the judge found that paragraphs 235 to 244 that Mr. Parker gave the undertaking on behalf of the firm in his capacity as a solicitor. The parties disagree as to the Court of Appeal's treatment of this finding. We've addressed the point at paragraphs 24 to 26 of our case. We say the Court of Appeal rejected Harcus Sinclair's challenge to the finding. The respondents say that the Court of Appeal considered that the undertaking was not an undertaking, but did not formally decide the point. I don't wish to take up time adding to what we've said in writing on this point, because the parties appear to agree that nothing turns on the disagreement. On either reading, the Court of Appeal's judgment, the trial judge's finding on this issue has not been disturbed, and the Court of Appeal's judgment contains no discussion of the point, so we are left with the reasoning and conclusion of the judge. And I submit that there are no grounds on which an appeal court should interfere with the judge's evaluation of the facts and his conclusion that Mr. Parker gave the undertaking on behalf of the firm in his capacity as a solicitor. The bargain struck between Harcus Sinclair and your lawyers was that Harcus Sinclair would comply with the undertakings in the NDA if your lawyers provided the confidential information. As recorded in Clause 1, your lawyers supplied Harcus Sinclair with the confidential information so Harcus Sinclair could give legal advice to your lawyers on behalf of claimants in the group action. There is a clear connection between the undertaking and Mr. Parker's role as a solicitor entrusted with privileged and confidential documents with a view to providing legal advice. Difficulties that may arise in the boundary in relation to undertakings to pay money simply don't arise in this case. Giving legal advice is at the core of a solicitor's work.
Mr. Coleman has a question, Mr. Coleman.
This isn't one of those cases in which either side, and I would have thought especially your clients, were just seeking to bind Mr. Parker. I mean, they were seeking to bind the LLP, which is a separate legal entity, which may or may not be properly regarded as a solicitor within the jurisdiction. That's a separate, within this jurisdiction, that's a separate issue. But surely what they wanted to get was the LLP's commitment, both to treating the information as confidential and the LLP's commitment not to act for other clients. It's not a case where, for example, the information was just being given to Mr. Parker, and therefore it was sort of ring fence around him, which would be suitably protected by his personal undertaking.
Well, my client had an interest in undertaking from both. Solicitors can move firms, for example, and the interest related to both the actual solicitor who acts on behalf of the LLP and the LLP itself. But on the question of conduct, there was a professional obligation, we say, on both the individual and the entity through which he works to comply with it. And breach of the undertaking whether by the firm or the solicitor, could essentially give rise to the same infringement of the legitimate interest, which we'll come on to analyse when we look at the judge's findings. On the judges, we submit that on these simple facts, the judge was bound to find that Mr. Parker was acting in his capacity as a solicitor, not in his private capacity. But in any event, the evaluative assessment on the facts as to the capacity in which Mr. Parker gave the undertakings is primarily a matter for the trier of fact in the absence of plain error. I turn then to issue 2 and 3, whether the supervisory jurisdiction may be exercised over Harcus Sinclair and Mr. Parker. These issues arise because since 1992, solicitors have been permitted to practice through incorporated bodies. As we explain in paragraphs 37 to 39 of our case, the reform was introduced by the Administration of Justice Act 1985, and the forms of practice were expanded again by the Legal Services Act of 2007. Harcus Sinclair LLP, the corporate body which I've been calling Harcus Sinclair for convenience, is the successor practice to a general partnership that was known as Harcus Sinclair. It was incorporated in March 2015. If Mr. Parker had given the undertaking prior to the incorporation of practice, then he and all his partners would have been responsible for its performance. And if the decisions of the courts below are correct, the changes in the rules regarding the permitted forms of practice have had the unintended effect, we say, of putting the undertaking beyond the reach of the court's supervisory jurisdiction. Turning to issue 2, Harcus Sinclair, the inherent jurisdiction has been developed by the courts, as we've seen. I submit it's for the courts to determine its scope, subject to respecting any act of parliament that may remove or limit the jurisdiction. I submit that the power to make an order over Harcus Sinclair as the body corporate on whose behalf Mr. Parker gave the undertaking is an incident of the inherent supervisory jurisdiction in respect of solicitors. No extension of the jurisdiction is required. Our submissions regarding the jurisdiction to enforce the undertaking against Harcus Sinclair is set out fully at paragraphs 32 to 79 of our case. There does not appear to be disagreement between the parties regarding the regulatory scheme, which we've described, or as regards the nature and origins of the jurisdiction, both generally and as it applies to solicitors. The dispute under issue 2 appears to centre on whether the fact that Harcus Sinclair is not an officer of the court prevents the court from making any order against it. We've explained in paragraph 43 of our case how the general jurisdiction of the old courts of common law and equity have been preserved by statute and vested in the High Court. And you'll find a helpful summary, may I suggest, at paragraphs 9A-67 to 9A-68 of volume 2 of the White Book, which we've got in the bundle at page 2124. Can I also ask you to note a typographical error in paragraph 43 of our case? It should refer to section 19(2)(b) of the Senior Courts Act, not 19(1)(b), which I apologise. In addition, there is specific provision that's been made for the preservation of the supervisory jurisdiction respective solicitors. As we explain in paragraph 52 of our case, the 1873 Judicature Act merged the professions of attorney, solicitor and proctor into a single profession. They were to be called solicitors of the Supreme Court and deemed to be officers of the court. And the supervisory jurisdiction previously exercised by the old courts of law and equity were transferred to the newly created Supreme Court. And the supervisory jurisdiction of solicitors has been preserved in successive statutes and is now recognised in section 50 of the Solicitors Act 1974. We've set this out in paragraph 52 of our, that paragraph 52 of our case. So the inherent jurisdiction exists, both generally and as regards to solicitors. The question is as to its scope, and the appellant's case on this issue can be distilled into three main submissions. One, the nature and scope of the inherent jurisdiction supports the existence of the power to make an order against the body corporate to enforce an undertaking given by a solicitor acting on its behalf. I'll repeat that. The nature and scope of the inherent jurisdiction supports the existence of the power to make an order against the body corporate to enforce an undertaking given by a solicitor acting on its behalf. Two, the exercise of the jurisdiction in respect of Harcus Sinclair is not inconsistent with the statutory framework. Three, justice supports the existence, I should say, of the power for which we contend. I make that point because the contours of the jurisdiction are shaped by considerations of pragmatism and justice. Turning then to the first main submission, the nature and the scope of the inherent jurisdiction supports the existence of the power to make an order against the body corporate to enforce an undertaking given by a solicitor acting on its behalf. This submission encapsulates the points that we've have made in our case, in particular paragraphs 57, 58, 59, 61, and 62. In Ex parte Bailey, decided in 1829, Lord Tenderden, the Chief Justice, said that the court's jurisdiction over attorneys is to be exercised according to law and conscience, and not by any technical rules. And we've referred to that in paragraph 61C of our case. The issue is to be approached as a matter of principle. The purpose of the supervisory jurisdiction is to secure the proper conduct of solicitors as officers of the court. If a solicitor gives an undertaking on behalf of the incorporated firm through which he practices, and the undertaking is not performed, a court of professional conduct is not required, I submit, to recognise any distinction between the solicitor and his firm. The court may make orders against both the solicitor and the body corporate to enforce the undertaking. This ensures that the jurisdiction over solicitors is effective so far as undertakings are concerned. It may be seen as an incident of the supervisory jurisdiction. We've already seen that Myers and Allman supports a pragmatic approach to the exercise of the supervisory jurisdiction. The respondents argue at paragraphs 31 to 37 of their case that since the basis of the jurisdiction is that solicitors are officers of the court, it follows that in exercising the jurisdiction, the court cannot make orders against someone who is not a solicitor. Therefore, the argument goes, the court cannot make an order against recognised bodies through which solicitors practice. And they cite the judgment of Lord Justice Christopher Clark in the Asabayev case. I do submit, as I said in opening, that this reasoning involves a non sequitur. It confuses the reason for the jurisdiction, on the one hand, with the scope of the court's powers when it is engaged, on the other. The reason for the jurisdiction is the court's interest in controlling its officers. It does not follow that the court, in the exercise of the jurisdiction, cannot make orders against body corporates through which a solicitor practice. I respectfully suggest that in the course of this appeal, we cannot perhaps hope to improve upon the work of the legal historians in uncovering the origins and nature of the inherent jurisdiction, and we've set out in our written case, paragraphs 43 to 58, these sources, and we make the submission that they support the enforcement of the undertaking as against Harcus Sinclair. Your lawyer's case as to the nature of the jurisdiction is supported, we submit, by Sir Jack Jacobs' scholarly review of the historical sources as to the nature and origins of the jurisdiction, and we have cited him freely at paragraphs 44 to 50 of our case. The highest courts in this country, Canada and New Zealand, have derived assistance from this article when determining questions concerning the inherent jurisdiction. We've given you the references at paragraph 44. I would be grateful if we could turn up, please, Sir Jack's article, tab 113, page 2237, 2237. I'm going to have to take this relatively quickly. I'll focus on some key passages in view of the time. The entire article repays reading, but especially for our purposes, pages 23 to 32, 46 to 49, and 51. Sir Jack locates the origin of the supervisory jurisdiction and the general power to punish for contempt. The contempt jurisdiction is not, of course, confined to officers of the court. If we could pick up the article at page 2239, towards the bottom of the page under the heading Historical Jurisdiction, Sir Jack considers the historical background to the inherent jurisdiction for what he says clues as to the nature and extent of the inherent jurisdiction of the court. And he explains that the superior courts of common law have exercised the power which comes to be called the inherent jurisdiction from the earliest times, and that the exercise of such power developed along two paths, namely by way of punishment for contempt of court and its process, and by way of regulating the practice of the court and preventing the abuse of process. So far as contempt is concerned, the superior courts assumed the power from the earliest of times in relation to certain offences in the nature of contempt and of its process, to attach and summarily punish the offender and subsequently releasing him on payment of the fine. These offences were contempt in the face and presence of the court, disobedience to the process of court, and then, and this is the important bit for our purposes, irregularities and misfeasances of its officers. And he cites Holdsworth's History of English Law, as we have done as well in our case. At page 20, the next page, 2241 in the bundle, Sir Jack considers the juridical basis of the inherent jurisdiction, and he says at the bottom of the page and over the next page, this is the last few words, the juridical basis of this jurisdiction is therefore the authority of the judiciary to uphold, to protect, and fulfill the judicial function of administering justice according to law in a regular, orderly, and effective manner. I emphasize the words effective manner because I submit that the power to make orders against the body corporate on whose behalf a solicitor gives an undertaking is necessary if the jurisdiction over solicitors and their undertakings is to be effective. Otherwise, there will be gaps. If we go back to
Mr. Coleman, Lady Arden has a question.
Sorry, you can take it at the end of this article if you wish, but much of this, of course, is covering ground which is very familiar to judges who will have met problems requiring the exercise of inherent jurisdiction. My question was really this. When you say you can make an order against an LLP, do you mean it can make an order against those members of the LLP who are solicitors? And could they not also now include persons who are not solicitors? And are you not in effect simply asking to lift the corporate veil?
The court, I submit, would have the power to make an order against anyone who's a solicitor in the LLP if it thought it was appropriate. In this case, we could have joined in all of the solicitor members of Harcus Sinclair LLP and sought orders against each of them. That would have been disproportionate. We focused on the relevant person. But in principle, the jurisdiction could extend that far, but it comes down to discretion. There would be no jurisdiction to make an order against a natural person who is not a solicitor. As regards authorised bodies who contain a mixture of solicitors and other people, in relation to whom a solicitor's undertaking has been given, well, the precise business structure of the company might be something to be taken into account when considering whether in the discretion it was the appropriate subject of an order. But we don't have that problem in this case. This was an old-fashioned law firm which changed its legal structure, but continued to be a conventional solicitors firm.
So I don't think there's any evidence on that.
May I
Come back on
ponder that observation and come back to you, my lady? That was certainly always the understanding.
My Lord Burrows and then Lord Briggs, I think.
Just as a follow-up, if I may, to Lady Arden's question, I'm not entirely clear what your answer was, because at one point you seem to be saying an order could be made against the corporate body, but then in the answer to the question, you said, well, it could be made against all solicitor members of that body. So what exactly are you saying?
It's both, my lord, and sorry for not making it clear. The jurisdiction enables the court to make an order against the solicitor members and the corporate body, and which it does in its discretion will depend upon its judgment as to what is appropriate in the circumstances. There may be cases where the appropriate target is only one solicitor and no other solicitor, and not the corporate firm. There may be cases where it's appropriate to join in a number of solicitors because they've been involved in the breach of the undertaking. There may be cases where, although the court has the power to make an order against the corporate body on whose behalf the undertaking has been given, it's not appropriate for some reason which can always be raised. It's not necessary to try and anticipate now all the points that could be raised in relation to a discretionary jurisdiction, but none of those points were raised in this case. In this case, everyone had assumed that the jurisdiction lay to make an order against Harcus Sinclair. No special facts about the business structure were prayed in aid. We're only debating this because we, your lawyers, informed the judge of the authority of Canet Asabayev at the end of the trial. No one had identified that case before then. But I do emphasize the point that with a discretionary jurisdiction, one doesn't need to try and advance or anticipate all the questions that may arise on particular occasions, because the discretionary feature of the jurisdiction can deal with them in due course.
Well, I sort of understand what you say by that, but our task, surely, if we're to embark in trying to sort this area out, we're going to have to give some clarity. And at the moment, it would seem to me that your answer as to how the discretion should be exercised depends on the court knowing something about who's working for the particular company, how many are solicitors, etc. So when you say, yes, an order can be made against the corporate body, if that corporate body is primarily not solicitors, the members aren't solicitors, I don't understand what the discretion is that's going to help.
Well, my lord, it will, if the corporate body wishes to raise facts relating to its business structure which make an order inappropriate, it can do so. If it doesn't do so, then the starting position will be that there are no special features, and there were no special features in this case. It was a straightforward undertaking given by a solicitor on behalf of a traditional solicitor's practice, save that it had been incorporated. And I don't concede that there will necessarily be cases where it's not appropriate to make an order. I simply say, well, if there are such cases, they can be accommodated in a discretionary jurisdiction.
Or Briggs.
Mr. Cohen, the very careful way in which you've put this suggests to me that what you're saying is that the court has discretion to make an order against the corporation because the undertaking that was given on its behalf was given by a solicitor, rather than saying the court has jurisdiction to make orders against an LLP performing legal services of the type that could only previously be performed by solicitors, so that in accordance with establishment authority about partnerships, it doesn't matter, for example, that the undertaking was given by a club. Suppose in this case, the undertaking had been given by a non-solicitor senior manager of Harcus Sinclair while it was still an unincorporated partnership. You would say, well, that doesn't matter. It was a partnership of solicitors and the firm can be brought within the jurisdiction accordingly. But I don't think you're saying that if after it becomes an LLP and the undertaking is given on its behalf by a senior manager who isn't in this is perfectly realistic possibility in this sort of commercial context, that then the court would have to do anything about it.
No, that's correct. I mean, you've got to have a solicitor as the anchor for the jurisdiction because there's a jurisdiction in respect of solicitors. The anchor we have is Mr. Parker and his conduct giving the undertaking. And then the question becomes, well, in the exercise of the court's jurisdiction over solicitors, what orders can we make to enforce it? And issues 2 and 3 have to be seen together because my case that the court has power certainly to make an order against Mr. Parker as the solicitor who gave the undertaking. The fact that he's not contractually liable on it doesn't matter. This is a court of conduct. But I also say that as a court of conduct, you can make an order against the LLP in which Mr. Parker, as a solicitor, practices. So I don't put it more widely than that. It's got to have a solicitor as to anchor the jurisdiction. And it's got to have conduct, not just a solicitor, but conduct by a solicitor. So you might have an authorized body which has lots of solicitors, but there's no solicitor whose conduct engages the jurisdiction.
Thank you.
And bearing in mind what Lady Arden, my Lady Arden said, I'll take this perhaps even more swiftly than I proposed, but can I just draw your attention to the bottom of page 2241, the reference to Lord Morris in Connolly and the DPP, which concerned abuse of process in criminal proceedings, but it expresses the argument or an aspect of the argument we seek to make. There can be no doubt that a court which is endowed with a particular jurisdiction has powers which are necessary to enable it to act effectively within such jurisdiction. I would regard them as powers which are inherent in its jurisdiction. The court must enjoy such powers in order to enforce its rules of practice and to suppress any abuses of process and defeat any attempt at thwarting its process. I rely in particular on the reference to acting effectively within such jurisdiction. I submit that in order to act effectively within the inherent jurisdiction to supervise solicitors, the jurisdiction must include, in an appropriate case, a power to make an order against the corporate body in which the solicitor works. The subject's definition, which Lord Fingham said in the Grobbelaar case had perhaps never been improved upon, is at page 51, but we've referred to it in our written case. We also do make the point that since the historical origin of the jurisdiction is contempt, there's no reason why, in terms of the nature of the jurisdiction, it can't, in an appropriate case, be exercised against a company. The contempt jurisdiction includes legal and natural persons. But we've set out the detail of that in our written case. Can we then leave, Sir Jack? You've got the references, it's familiar to you. At paragraph 61 of our case, we cite two cases where the court has exercised the supervisory jurisdiction over people who were not attorneys or solicitors. I don't want to make too much of these authorities because they haven't been approved on appeal, but they illustrate the flexible and pragmatic way in which the jurisdiction may be exercised. I won't take you to them, but you've got the references. In one of the cases, re Human Lewis, a divisional court held that the supervisory jurisdiction can be exercised to divest someone who wrongly obtains documents or other property by pretending to be solicitor. So a non-solicitor pretending to be a solicitor can come within the jurisdiction. And if these exceptions are valid, they undermine the respondent's categorical rule that the supervisory jurisdiction cannot be applied in any way to people who are not solicitors. Now, I submit that our case has at least as strong a claim on the inherent jurisdiction as re Human Lewis did. Our case is not about anyone obtaining property by pretending to be a solicitor. It's about a genuine solicitor who obtained privileged and confidential information against undertakings that he gave on behalf of the recognised body that he practised in.
Mr. Coleman, does Human Lewis turn on some notion of estoppel?
Well, that's how it was subsequently interpreted. That's one way of seeing the case, but and I'm happy for it to be seen in that way. But the point is that the court found a way of exercising a jurisdiction over someone who was not a solicitor. It's a pragmatic way of dealing with a particular problem that arose in that case.
If the true explanation of it is that it's an estoppel, then that wouldn't extend to the present case, would it?
No, estoppel wouldn't. It could be distinguished. If one wished to distinguish it, one could certainly distinguish it on that ground, my lord. But I submit there's no need to try and distinguish such a case. It's Hurst and Middleton is the decision you're referring to, my lord, which we referred to at paragraph 61b of our written case.
Thank you.
So, for those reasons, I submit that the power to make an order against Harcus Sinclair to enforce the undertaking does accord with the nature and scope of the inherent jurisdiction. Moving then to the second submission regarding Harcus Sinclair, and that is that the exercise of the jurisdiction in respect of Harcus Sinclair is not inconsistent with the statutory framework. We make this point in paragraph 60 of our case. Can I please, in view of the time, just give you a couple of references? Firstly, to Sir Jack Jacob, again, page 2238. He said that the court may exercise its inherent jurisdiction even in respect of matters which are regulated by statute or by rule of court, so long as it can do so without contravening any statutory provision. And that encapsulates the relationship between the inherent jurisdiction and statute. That's page 2238. The same point emerges or can be seen in the decision of the House of Lords in Harrison and Chew, which we cite at paragraph 60 of our case. Again, I won't go to it if I may, but the point was discussed in the speech of Lord Lowry. The reference to the bundle is pages 1176 and 1177. And he cites Cook's Institutes of the Laws of England. It is a maxim in the common law that a statute made in the affirmative without any negative expressed or implied does not take away the common law. Neither party has identified anything in the relevant statutory framework, in particular the Administration of Justice Act and the Legal Services Act, which is inconsistent with the exercise of the supervisory jurisdiction in the manner I have described. And as we submit in paragraph 65C of our case, the relevant inquiry is not whether the statutory scheme affirms the inherent jurisdiction, but whether it clearly takes it away. There's nothing in the statutory scheme that limits or takes away the jurisdiction. In paragraph 47 of their case, the respondents cite examples in the insolvency context where Parliament has declared that newly created office holders are officers of the court. We're not concerned with newly created office holders. We're concerned with the court's power to make orders as an incident of its jurisdiction respective solicitors against corporate bodies in which solicitors practice. Turning to the third submission, which is that justice supports the existence of the power to make orders against incorporated bodies to enforce undertakings given on their behalf. We've identified a number of considerations of justice at paragraphs 57, 59, 62, 63, and 70, 73 of our case. I do submit that the court's ability to enforce solicitors' undertakings cannot depend on the legal form of the solicitor's practice. I've already acknowledged that there may be discretionary factors that make it appropriate depending on the precise business arrangements and who gave the undertaking and so on. The concerns expressed by the judge at paragraphs 246 to 247 about the implications of his conclusion that the inherent jurisdiction could not be exercised in respect of Harcus Sinclair are compelling. Solicitors' undertakings continue to be of fundamental importance in everyday practice. Take conveyancing as perhaps the most familiar example. We've cited the observations of Lady Justice Smith in Briggs and the Law Society at paragraph 11 of our case, where she said breaches of undertakings undermine not only confidence in the profession, but confidence in the whole system of undertakings on which property transactions depend. The courts provide the only robust mechanism for giving effective relief for a breach of an undertaking. In some cases, the relief will have to be sought urgently. Of course, this is not a conveyancing case, but what is good for this case will be good for conveyancing cases. And conveyancing is only one familiar instance in which undertakings are given. They feature in transactional work. They may be given to clients, actual or potential. They may be given to the court. They may be given for the benefit of fellow solicitors, as happened in Fox's case, in Fairfawn, and in this case. And they may be given to the regulator itself. Of course, the court is rarely called upon to exercise the jurisdiction and practice because solicitors understand the sanctity of their undertakings and do not seek to escape from them. But the scheme for enforcing undertakings cannot depend solely on the integrity of the solicitors to voluntarily comply with them. About 60% of practices are now incorporated. A solicitor who practices in an incorporated practice practices, of course, on behalf of the firm. If a solicitor is called upon to give an undertaking, he or she will naturally, in the modern age, give it on behalf of the firm, or often will do so. The recipient may not be a lawyer, is unlikely to recognise the fine distinctions that now need to be drawn on the law as stated by the Court of Appeal. I submit that there ought to be a unified approach to the enforcement of undertakings under the jurisdiction, free of unjustified and unnecessary gaps, so that it can provide an effective remedy to all recipients of undertakings. The law, as stated by the Court of Appeal, I submit, gives rise to capricious results unrelated to the justice of the particular case, and the discretionary nature of the jurisdiction enables the court to do justice, as I say, if there are particular features of the business structure that require a particular outcome. We make the point in paragraph 59 that the incoherence of the law is all the more striking when one considers that the bodies through which solicitors practice owe materially the same professional duties as a solicitor. As we submit in paragraph 63, the complexity of the regulatory scheme should not be allowed to obscure what is at its heart a simple question with a clear answer. It may be helpful to consider the hypothetical case of a solicitor who, before the rules permitting incorporated practices were first introduced in 1992, refused to honour an undertaking he'd given on behalf of a company through which he was conducting his practice in breach of the rules. It's difficult to see that a court would have been troubled by the fact that the company was not an officer of the court, or by the fact that the company had given the undertaking only as agent, or that it would have reached the conclusion that both the solicitor and the company were beyond the scope of the court's inherent jurisdiction. Mr. Crowe explains in paragraph 35 of his case that the court could indeed, in days gone by, order attorneys to be pitched over the bar, physically thrown out of the court. And we suggest that judges who develop the jurisdiction with such pragmatic instincts would not have seen any distinction between a lawyer, attorney, and the corporate manifestation of that attorney or lawyer. That's the position before 1992. I submit there's nothing in the regulatory scheme which has changed the position. My Lady Arden has already referred to Cordery, in which concerns are expressed about the implications of this decision. The reference is at page 2163. I don't want to overstate the concerns. Let me just read to you what they are. Given that most solicitors now practice through some form of entity, the practical effect of the decision on Harcus Sinclair is that most undertakings can now be enforced by a breach of contract claim. That can now only be enforced by a breach of contract claim. Alternatively, an aggrieved party can hope that the risk of being reported to the SRA will encourage compliance. This clearly falls well short of the protections that made undertaking such a powerful tool, and clients and law firms alike may want to review their reliance upon them. I submit there's nothing about the inherent jurisdiction which requires it to be emasculated in this way. Turning briefly to Asabayev and Michael Wilson partners, I can now deal with this shortly. We have set out full submissions at paragraph 64 to 69 of our case. And I've already explained why Lord Justice Christopher Clark's reasons for thinking that the jurisdiction could not be exercised in respect of recognised bodies were wrong. He relied in particular on the fact that such bodies were not officers of the court, and that the relevant legislation did not make any provision for the exercise of the jurisdiction in respect of non-solicitors. See paragraphs 46 to 48 of his judgment, page 1310 of the bundle. The Court of Appeal in that case did not have to consider the problem that arises in this case in relation to solicitors' undertakings. Asabayev had nothing to do with either undertakings or with the recognised bodies through which solicitors practice. The solicitor in that case was practicing unlawfully through an unauthorised company. Lord Justice Christopher Clark did not, therefore, have to consider whether, as part of the incidental powers necessary to make the jurisdiction in respect of undertakings effective, the court can order a corporate body to comply with an undertaking that a solicitor has given on its behalf. And we respectfully submit that insofar as Lord Justice Christopher Clark's judgment is to be read, is saying that the court, under its supervisory jurisdiction, can never make an order against a corporate body, that he was wrong. We also submit that this was not in any event part of the ratio, insofar as that matters in this court. The actual ground of the decision in Asabayev was that the supervisory jurisdiction could potentially be available on the basis that the defendant company might have been pretending to be a solicitor. But the court did not have to decide that question because there were no grounds for refusing to stay the proceedings under the Arbitration Act. And that view of the case is supported by the very short judgment of Lady Justice Black at page 1318 of the bundle. In other words, if you follow Lord Justice Christopher Clark's reasoning, you will see that he would have reached the same conclusion even if he'd thought that the jurisdiction could be exercised in respect of recognised bodies, because there was simply no basis for not staying the claim under the Arbitration Act. There is a final point that should be mentioned. You understand already the circumstances in which this issue arose. My Lord Hamlin has a question.
Why you say so? Why was the Court of Appeal consider itself bound by it in this case? They not argued as the obiter, or?
Well, I argued that it was obiter. My recollection is that Lord Justice Henderson said, well, even if it's strictly obiter, on a point of practice, we should follow this decision. But the Court of Appeal in its judgment did say it was bound by it. It doesn't say why. I made my submission that it wasn't bound. Harcus Sinclair brought these proceedings invoking the inherent jurisdiction of the court. In other words, the claim proceeded on the basis that it was subject to the inherent jurisdiction. Until we raised the point, having discovered Asabayev, it had not occurred to any of the lawyers involved in this case that Harcus Sinclair might be beyond the scope of the jurisdiction. And the course that this case has taken, I submit, suggests that the decision of the Court of Appeal, insofar as it states the law, is out of steps with the expectations of the profession. We have also found one case where a court did enforce an undertaking against an LLP, although there was no discussion of this point. We can provide it to the court. It was in the trial bundles before the judge. It's called Clark and Lucas Solicitors LLP, 2010, 2 All England Reports, 955, a decision of Sarah Asplin QC, as she then was, sitting as a Deputy High Court judge. Although there's no discussion of the point and it's not of precedential value in that sense, the limits of the supervisory jurisdiction are informed by how judges exercise it in practice. So the case is relevant to that extent. I can deal with issue 3, Mr. Parker, and indeed issue 4 shortly. We deal with the position of Mr. Parker at paragraphs 74 to 79 of our case. The position is straightforward. The judge and the Court of Appeal have confused the questions of contract with the question of professional conduct. The contractual position is that Mr. Parker is not a party to the undertaking because he made it as agent for Harcus Sinclair. It does not follow that he is not professionally responsible for seeing that the undertaking he gave on behalf of his firm is performed. At paragraph 19D of our case, we cite In re Gray, a decision of 1892 in the Queen's Bench, Lord Esher, who said this, and I'll give you the bundle reference because we don't have the quote in our case, but we have the reference. It's page 1136. The court has a punitive and disciplinary jurisdiction over solicitors as officers of the court, which is exercised not for the purpose of enforcing legal rights, but for the purpose of enforcing honourable conduct on the part of the Crown's own officers. The court has a right to see that its own officer does not act contrary to that duty. As we submit in paragraph 78 of our case, there were compelling reasons for the court to exercise its undoubted jurisdiction over Mr. Parker as a solicitor to secure the performance of the undertaking he'd given on behalf of his firm. He gave the undertaking in relation to a matter that he was dealing with on the firm's behalf. It was his matter. He was the solicitor with primary responsibility for honouring it. Mr. Parker's conduct put the firm in breach of the undertaking. See paragraphs 344 to 345, the judgment. The performance of the undertaking was entirely within Mr. Parker's control. Other considerations might, of course, apply if a solicitor has lost control of the performance of an undertaking. Harcus Sinclair had a regulatory obligation to perform the undertaking itself. It could only act or refrain from acting through its members and agents, in particular Mr. Parker. And Mr. Parker, as a member of Harcus Sinclair, is under a direct regulatory obligation to ensure that his firm complies with the SRA's rules. see Rule 8.1 of the authorization rules, which we cite in paragraph 78 of our case. This appears not to be in dispute. We submit that the respondents are wrong to suggest, as they do at paragraph 56 of their case, that this is irrelevant. Since the court's jurisdiction exists to ensure solicitors act honourably in accordance with the required professional standards, the court can look at the professional rules made by the regulator under its statutory powers to see what those standards are. As a matter of professional conduct, Mr. Parker, we submit, was under a professional duty to see the undertaking was performed, whether he gave it personally or on behalf of his firm. At paragraph 57 of their case, my lord, I see the time.
Yes.
Well, I don't know if you're anywhere near finishing.
I'm very near finishing the point, and my lord, Lord Briggs, has raised his hand.
Well, I'm happy to leave it till 2 o'clock, but you may want to think about the question.
Yes,
before you answer it.
I'd be grateful to have the question.
But my question really is this: are you really saying that whenever a solicitor gives an undertaking, which is a matter of contractual analysis, is given not on his own behalf, but on behalf of his LLP firm, he thereby incurs a disciplinary professional responsibility to ensure that his firm, however big and however little power he may have over its conduct, because he may be a very junior member of the firm, complies with it?
He may do. He has an enduring duty to act professionally in accordance with proper professional standards. Whether he has breached that duty will depend on the circumstances in which the undertaking was given and the control over which he has in relation to its performance. There may be cases where one says, well, it's entirely excusable that the undertaking hasn't been performed so far as the solicitor is concerned, but that is not this case. My lord, Lord Burrows has a question.
Could I also just ask you to think about, or indeed to ask you whether this issue has ever been raised? You said that the contractual position is that the company is bound by the undertaking. Has there been any question as to whether this might be one of those rare cases where the individual is also bound as agent? That is, that contrary to the normal rule that the agent drops out, there is such a personal role played by this solicitor's undertaking that actually both are liable in contract.
That point has not been argued in this case. I'm not aware of any consideration being given to it in any commentary or authority, but it's certainly a point that could be run. My lord, I'm in your hands. It will take me a minute or so to complete issue 3, if it's convenient.
Very well. We'll take a minute or two, but if it's longer than that, we'll have to.
Yeah. At paragraph 57 of their case, the respondents say that the judge found that Mr. Parker had made an honest mistake and was unaware of the restriction, and they proceed to argue that his conduct does not meet the threshold of inexcusability required to warrant the court's intervention in the exercise of the supervisory jurisdiction. We submit that Mr. Parker's unawareness of the undertaking prior to January 2017 cannot assist him. I've already addressed you on the seriousness of the breach, but in any event, as we've seen from the cases, enforcement of an undertaking does not depend upon the moral quality of the breach. As a matter of professional conduct, solicitors must perform their undertakings unless there is good reason not to. Careless inadvertence is not a good reason, nor is persistence in a breach after the undertaking has been drawn to the solicitor's attention. The respondents say in paragraph 55 of their case that Mr. Parker's only involvement in the undertaking is that he signed the NDA. I submit that is a wholly unrealistic view of the facts and of Mr. Parker's professional obligations.
Thank you. If that's a convenient point, we'll
Thank you.
adjourn now and we'll resume at 2 o'clock, please.
Thank you, my lord.
Thank you very much.